Don't say might be.
I'll just your lordship.
ना ना, आप कहना क्या चाह रहे हो कि बिल्डर ने गलत काम किया है?
Just
आप छुपाएं और फिर एफ करके मेरे ऊपर बर्डन डालें। नो सर, सॉरी सर,
saying
ये
about
हराम कहानी छोड़िए। आप सीधा कानून वो जजमेंट लेके आइए सुप्रीम कोर्ट का। प्रॉब्लम ये है कि आई एम रिक्वायर्ड टू टीच द लॉयर्स एज इफ दे आर द नर्सरी स्टूडेंट्स।
why
यस,
2000
मुझे क्या लेना देना? वंस इट वाज नॉट चैलेंज देन नॉट चैलेंज।
your
मैं
lordship
क्या करूं उसके लिए?
at that time it was not
सॉरी
I
सर,
was
आप लोगों की अननेसेसरली बहस सुन के 5 मिनट का केस को 20-20 मिनट बर्बाद हो रहे हैं इस कोर्ट में।
this
Mr. Counsel, you are not answering the legal question.
I am answering
No, sorry, sir. The way you are answering, I am not going to waste my time.
your lordship in observation.
Sir, now please keep quiet, sir.
Your lordship
I would request now, please don't utter a single phrase. Sir, I will not allow you to speak. Don't cross your limits.
विक्रय मूल का विवरण your lordship if your lordship may see on the last paragraph of page number 26 यह कि उपरोक्त संपत्ति चूंकि यूनिट नंबर 30 का भाग है और उपरोक्त यूनिट नंबर 30 की साइट का विक्रय हम विक्रेता पक्षकार नंबर 1 के द्वारा आप विक्रेता पक्षकार नंबर 2 के हक में रजिस्टर्ड विक्रय पत्र दिनांक 23/6/2004 के दस्तावेज नंबर 968 के जरिए कर दिया गया था, जिसमें इस संपत्ति का पूर्ण विक्रय मूल्य प्राप्त कर संपत्ति कब्जा दे दिया गया था और सिर्फ इस संपत्ति का पंजीयन होना शेष था। इसलिए विक्रेता पक्षकार नंबर 1 के द्वारा बिना किसी मूल प्राप्ति के इस दस्तावेज पर हस्ताक्षर किया जा रहा है। Now, your lordship, this sale deed is talking about this property as the additional portion of unit number 30. Unit number 30 is
So
my
you mean to say that the builder has done some illegal thing?
I do not intend that. That might be a case.
Don't say might be.
Your lordship,
Don't say might be.
I'll just your lordship.
ना ना, आप कहना क्या चाह रहे हो कि बिल्डर ने गलत काम किया है?
Your lordship, that
अगर आप कहना चाहते हो तो इसका कानून आपको पता है, इसलिए आप थोड़ा सा माइट भी वर्ड यूज कर रहे हो। हाउ कैन यू फाइल अ काउंटर क्लेम अगेंस्ट द कोडिपेंडेंट?
no, your lordship, no.
So you are not claiming any relief against the builder?
No,
You are not alleging that the builder has raised some illegal construction?
Your lordship, I'm not alleging that the builder has made some illegal.
Your contention is that the plaintiff himself has raised some construction over the land which was left for conservancy purposes. Is it your case? क्योंकि आपका शायद प्लेंट फाइल नहीं हुआ है।
प्लेंट
आपने फाइल नहीं किया, देयरफॉर मैं समझ नहीं पा रहा हूँ कि केस क्या है, इसलिए मैं जो भी प्रश्न पूछ रहा हूँ आउट ऑफ माय ओन अंडरस्टैंडिंग है, मे नॉट बी द एग्जैक्ट केस ऑफ द पार्टीज, देयरफॉर नो आई विल नॉट अर्जेंट सर। So you have filed the documents which according to you were sufficient to also decide the dispute in question.
Your lordship may see the layout which I have.
What is the case? What is your case?
Yes, I'm coming.
Whether you are claiming that the builder has done something illegal.
My case is based only on three positions, your lordship. Kindly appreciate.
Have you filed the written statement before the trial court?
Yes, written statements have been.
Why you have not placed it on record?
Yeah.
Why you have not placed it on record? Because your entire case is based on your written statement. Why this game of hide and seek, sir?
No, your lordship, not a hide.
It is not for you to give a certificate to yourself. It is not a game. It is not for you to give a certificate to yourself.
I humbly.
How can you refer to something which is not on record if according to you written statement was not necessary document? Then please don't refer to it.
Lordship, if your lordship may see.
I don't require anything. I will decide it.
Lordship, just.
आप छुपाएं और फिर एफ करके मेरे ऊपर बर्डन डालें। No sir, sorry. I will not allow you to refer any of your defense taken in your written statement.
What my application I filed.
Now please refer to the application only.
Order 1 rule 10.
Yes sir. What is mentioned in 110?
Sir, this is page number 30, annexure P5.
Right sir.
Your lordship, if may see. What my second point is, and what I have done in this application, your lordship, that I have written the points wherein in the plaint and in the WS the question of this necessary party has arisen, like how this party.
Counsel, your contention is that only he can tell the correct things. So why can't you bring him as a witness?
Your lordship, that is also true. If your lordship may give me that liberty.
अरे मैं आपको ट्रायल चलाऊं?
I have.
Mr. Counsel, मैं आपका ट्रायल चलाऊं?
Sir, I have made that.
Why should I become a party to the trial?
I have made that application.
Your only contention is just a minute. Your only contention is only the builder can tell the correct and give the correct information. This is the only contention for impleading him as a party.
Lordship.
Not just for seeking the correct information, you want that someone should be made a party. Is it a good ground for impleading him? That is the only question.
Yes, Lordship.
Yes, now please cite some judgment which says that if a person can give a correct position, then he becomes a necessary party.
Your Lordship, the main issue which is being.
Please cite the judgment. Don't tell me that for just decision. Give me that if a person is can be of assistance to give the correct information, then he should be impleaded as a party. We are dealing with one time. We are not dealing with a situation where you had sought the examination of the builder as your witness and it was rejected.
Your Lordship, that is.
I am not on that issue. We are not on that
Your
issue.
Lordship, what had happened was I had made that application before the trial court also, which Your Lordship is
सर
saying.
ये हराम कहानियां छोड़िए. आप सीधा कानून वो जजमेंट लेके आइए सुप्रीम कोर्ट का जिसमें ये लिखा है कि if a person is in a better position to give information, then he becomes a necessary party.
Your Lordship, in my grounds.
Forget about your grounds. Your grounds are not
I'm
law.
talking about the judgment only. I've written the judgment on.
आप सीधा judgment citation बताइए.
Yes. 2010 7 SCC 4.
उसमें वो पढ़ के बताइए.
Lordship.
2010 Volume 7 SCC
417. Mumbai International Airport Limited.
जी क्या लिखा है सर? If a person is in a position to give the correct facts, then he becomes a necessary party.
I have a copy for Your Lordship also.
अरे मैं तो अपने खुद निकाल लूंगा यहाँ से, आप तो बताओ. आप वो तो आप लाइन पढ़ के बता दो.
The definition.
आप उतना लाइन पढ़. अरे forget about the definition of necessary party. I know that.
Your Lordship, what the observation of the court?
नहीं, I don't want any observation. First of all, tell me the facts because the observations are made in the light of the facts of that case. Any observation made in a particular circumstances cannot be treated as a general rule. Tell me the facts whether the person who was sought to be impleaded was being impleaded only because of the fact that he is in a better position to tell the correct facts. If that is the law, then I will immediately issue notice. No difficulty.
Lordship.
उतना पढ़ के बता दीजिए.
Lordship, in this judgment.
Please read out the facts. That what were the reasons for impleading a particular person or the institution as a party?
Lordship,
उतना पढ़ के बता
the
दीजिए.
facts are so that the appellant filed an application seeking impleadment as an additional defendant in the said suit. The plea raised therein was that in view of the appellant's object to make the airport a world-class airport, the appellant's interest was likely to be directly affected if any.
Yes. Whether the interest of the builder is likely to be affected. Now please come to paragraph 9.
Paragraph
9. What are the reasons for impleading the builder? बस उतना सा पढ़ के बता दीजिए.
Lordship, paragraph 9 of this judgment.
Of your application, भाई साहब.
That the learned trial court through the impugned order.
Sir, paragraph 9 of your application.
Oh, sorry, Your Lord. Sorry. यह कि इस प्रकरण में एकमात्र समदड़िया बिल्डर ही हैं जो वादग्रस्त स्थान को की सही जानकारी दे सकते हैं.
बस जानकारी दे सकते हैं या फिर वह निर्माण कार्य होना था अतः आवश्यक पक्षकार. ऐसे अगर हमने आपका प्रोपोजिशन ऑफ लॉ एक्सेप्ट कर लिया, हर विल में हर अटेस्टिंग विटनेस नेसेसरी पार्टी हो जाएगा. हर केस में हर विटनेस नेसेसरी पार्टी हो जाएंगे.
Lordship, that is absolutely true, Your Lordship.
चलो कुछ तो माने आप.
Lordship,
हर विटनेस को पार्टी बनाना पड़ेगा to the suit because he can throw a light on the dispute.
Lordship, why I am saying about the party?
I am talking about the general law which will be propounded in case if your contentions are accepted.
Lordship,
your reason for impleading the builder is that the builder is in a best position to narrate the correct facts, right?
Lordship.
अब अगर आपका सपोज विल का सूट है अंडर सेक्शन 63, 68 of Indian Succession Act, one of the attesting witness is required to be examined, right?
Lordship.
अब आप उसको पार्टी बना दो because he will prove the will.
Lordship, why
आप हर आई विटनेस को पार्टी बना दो.
On my facts, why?
732/2020.
Lordship, if your Lordship may see my relief clause, Your Lordship may please appreciate my relief clause.
भाई साहब मैं आपकी रिलीफ क्लास ही देख रहा हूँ.
Sir,
मैं आपकी पिटीशन की रिलीफ क्लास नहीं देख सकता. Try to understand the things. This is 227. I am not exercising my original jurisdiction.
Your Lordship, that's
Problem ये है कि I am required to teach the lawyers as if they are the nursery students.
why,
Yes,
Your Lordship.
Mr. Counsel, I am exercising my power under 227. I am deciding your petition on the basis of relief which was sought by you before the trial court.
Your Lordship, I've sought this relief before the
1732.
trial court.
I have already heard you, sir.
Kindly appreciate, Your Lordship. One submission I have to make, Your Lordship. Kindly appreciate. I've already made this application to for this necessary party to be in the witness box. That is also has been dismissed, Your Lordship. Way back in 2000.
मुझे क्या लेना देना? Once if it was not challenged, then not challenged.
Your
मैं
Lordship,
क्या करूं उसके लिए?
at that time it was not.
Sorry, sir.
It was considered ex parte.
No, sorry, sir. Sorry, sir.
Lordship,
अगर आपको आपके खिलाफ कोई ऑर्डर हुआ, आपने चैलेंज नहीं किया, how can take the shelter of that? 1732/2024. This petition. No, sir, I have heard you enough.
Your Lordship, if
This
you see my
petition under
layout,
Article 2. Sir, SLP is available to you, so don't worry.
Your Lordship,
I have heard you enough.
why I'm saying this, Your Lordship,
Whatever it may be.
if Your Lordship may see the layout which is of the society, Your Lordship, my
MP
last
number 1227 of MP number 1732 of 2024. आप लोगों की unnecessarily बहस सुन के 5 मिनट का केस को 20 मिनट बर्बाद हो रहे हैं इस कोर्ट में. And you people are not ready to understand the real controversy. What can I do? 173. When I am asking you a simple question, whether a witness can be made a party, whether a witness can be treated to be a necessary party, you are not answering that.
in this
Mr.
case,
Counsel, you are not answering the legal question.
I am answering.
No, sorry, sir. The way you are answering, I am not going to waste my time.
Your Lordship, in this
The
case,
way, the manner in which you are answering, I am not going to waste my time.
Your Lordship, what your
173.
observation?
Sir, now please keep quiet, sir.
Your Lordship,
I would request now, please don't utter a single word. Allow me to dictate the order. I have heard you enough. I have understood that controversy. 1732/2024. This petition under Article 227 of Constitution of India has been filed against the order dated 7/3/2024 passed by 13th Civil Judge, Senior Division, Jabalpur in RCSA number 69/2024. The effects of the present case in short are that the respondents have filed a suit claiming easementary right. The petitioner filed an application under Order 1 Rule 10 CPC for impleading the builder as defendant. By the impugn order dated 7/3/2024, the trial court has rejected the said application for the system. Challenging the order passed by the trial court, it is submitted by counsel for the petitioner that petitioner has not sought any relief against the builder. He wanted to implead him as a defendant on the ground that he will be in a better position to narrate the facts effectively. And earlier, the petitioner had filed an application for summoning the builder as a witness, which was rejected by the trial court. And under these circumstances, the petitioner is left with no other option but to implead the builder as defendant. Heard the learned counsel for the petitioner. The word necessary party means that in absence of whom no effective decree can be passed. Well, let's stop. It is the case of the petitioner that the builder will be in a better position to narrate the correct facts. Just for this, that means the petitioner wants to implead the builder just to seek a clarification on certain facts regarding the contents of the 2 different sale deeds executed by him. Well, let's stop. It is the case of the petitioner that although the plaintiff is a dominus litis, but where the court comes to a conclusion that the impleadment of a defendant is necessary for just decision of the case, then in spite of the principle of dominus litis, the court can direct the impleadment of the defendants. Next. Therefore, the question for consideration is as to whether the impleadment of a witness as a defendant is necessary. The impleadment of a person whose rights are not being adversely affected and against whom no relief has been claimed can be pleaded as a party in the civil suit or not. Full stop. As already pointed out, the meaning of necessary party means without whom a just and effective decree cannot be passed. Once no relief has been sought against the builder and no right of the builders are being adverse, and it is not the case that any right of the builder will be adversely affected, then this court is of considered opinion that the builder cannot be said to be a necessary party under the facts and circumstances of the case. So far as the rejection of the application filed by the petitioner for summoning the builder as a witness on earlier occasion is concerned, it is fairly considered by counsel for the petitioner that the said application was rejected way back and the said order was never challenged. Once the order thereby rejecting the prayer of the petitioner to summon the builder as a witness has already been challenged and it has attained finality, in there this court cannot allow the builder to be pleaded as a defendant in the suit. Considering the totality of the effects and circumstances of the case, this court is of the considered opinion that no case is made out warranting interference. Accordingly, the order dated 7/3/2024 passed by 13th Civil Judge Senior Division Jabalpur in RCSA number 32-660-00069/2014 is hereby affirmed. The petition fails and is hereby dismissed. गलती आपकी कहीं और है.
Lordship, the question involved is
I have
not
already
two
dictated the
different
order,
CPs.
sir. I have
Yes,
already
yes,
I have already dictated the order. If you think that I have passed an erroneous order, please file SLP. Sir, I will not allow you to speak. Don't cross your limits. Thank you, sir.
Item number 15, Sri Ashok Kumar Pali.
आप लोग जिस तरीके से प्रोजेक्ट करते हैं अपने आप को, ऐसा लगता है कि गारंटियां देके आए थे. So don't spoil your image, sir. If you are not satisfied, you have a remedy. आपको नहीं रेमेडी लेना सर, आप ही को मेरे जैसा ऑर्डर करना पड़ेगा. How can you claim? That means you had given some guarantee. And whether it is a part of a lawyer to professional duty of the lawyer to give a guarantee. And if you have given guarantee, then why I should be bound by it?
No guarantee.
So once I have already dictated the order, yes, my order may be erroneous. But to the best of my knowledge, I have passed the correct order. If you feel that it is an erroneous order, please file an SLP. And don't pressurize me, try to pressurize me. At least I will not come under any pressure. I had given you enough opportunity. Fine, sir. Next, sir.
15.